I'm ready, Judge.
All right. Go ahead, bailiff.
It's muted, I believe.
Apologize. Thank you, Justice Cohen. Good morning, Your Honors. The matter before the court this morning is the case entitled Christian Jerry versus Chad Merchant Jr., case number 23 AP 370. Representing the appellant, Christian Jerry, is attorney Luke Richter. Representing the appellee, Chad Merchant Jr., is attorney Brooks G. McArthur.
Right, appellant's counsel, please introduce yourself and your client, and then you may proceed with your argument.
Hello, Judge. My name is Luke Richter. I'm the counsel for the appellant Christian Jerry. We are here on a matter for an appeal of a family court child custody decision. And specifically, my appeal has to deal with the application of 15 VSA 665A as
Mr. Richter, there's no appeal on the custody determination. It's really parent-child contact, correct?
Correct.
Okay, thank you. Sorry about that.
No problem. So I like the back and forth. The heart of my appeal is we are curious about the application of 665A and whether or not it should be non-discretionary when there has been findings of domestic violence. My client is a survivor of domestic violence. It was acknowledged by this court that she was a survivor of domestic violence. She has a young child with her abuser. And we believe that the Vermont legislature mandated the courts to, when there's a finding of domestic violence, to apply the standards and the safeguards that we can find in 15 VSA 665.
Mr. Richter, is it your determination that it's not? So those are considerations that the trial court would apply to parent-child contact with the ability to do certain things like limit overnights and limit it. But to strictly apply each one to say if there's domestic violence, there will not be any overnights. Is that how you read the statute?
No, I read the statute and when there's a finding of domestic violence, the court is then mandated to take into account the security and the safety of both the survivor and the child. And I believe the statute provides the court with tools to perhaps limit visitation, or to be, for lack of a better term, to almost be draconian with visitation if the court finds it necessary. I believe the legislature has asked the courts to consider the history of domestic violence, of the 10-year history of domestic violence when making these considerations. Because as we know in the 21st century, domestic violence is a very complicated circumstance for a survivor to be in, where there's underreporting, and it's it's a statute that I believe is meant to help save a life. And I think that the legislature wants courts, if there's a finding of domestic violence, to take that seriously and consider the history of violence, and then to ensure that safeguards are in place.
But didn't the trial court put safeguards in place here?
I don't believe they did. No. I think the trial court mistook lack of opportunity for actual reform. The trial court focused its decision on 3 supervised visitations over the course of like 9 months. He had no other visitations. He was unwilling. My client was never asked to bring the child to the supervised visitation center in St. Albans during that time period. The only visitations were the ones where she agreed, like on a birthday or something. I think there were 3 or 4, but that's within the trial court's discretion. We understand, but we also think that the trial court really came down to it was mistook lack of opportunity to continue abuse or actual reform.
I'm not sure what that means.
Well,
what does that mean, please?
Yeah, it's in the facts. My client got away from her abuser, and there was an incident in August of 2022 where no matter whose interpretation you take, a toy was, was tossed or thrown. It struck her, left a bruise. According to my client, he then charged her, and she had luckily had a hammer nearby where she was able to intimidate him by banging it on the table to prevent a future attack. That was the last time she allowed him in her residence. And that was the last time she allowed unsupervised contact, or at least a contact without another party around. So for the next, I think, 10 months or so, she just didn't allow the opportunity for him to abuse her. She wasn't alone with him in such a way where he would have the opportunity to abuse her. And that, I think, is reflected in the record. And I think that's where I think the trial court mistook lack of opportunity for actual reform. He didn't have the opportunity to continue abusing her. And the trial court did not make a finding on previous abuse, but the record is what the record is.
Your time has expired, counsel. You're going to have to leave it there.
Okay, thank you very much for listening to me. Sorry for going over.
You're welcome. All right. Appellees, counsel, you may introduce yourself and your client and proceed with your argument.
Thank you, Your Honor. May it please the court, my name is Brooks MacArthur. I represent the appellee, Chad Merchant. If the backdrop looks a little familiar, I am in the lawyer's room. I thought this was an in-person hearing. My position is a couple things. One, I believe the appellant misstates and misunderstands the statute at issue. First of all, it's up to the judge to make credibility determinations as to facts. I think Judge Hoare did that. What I believe the appellant wants to do here is to change the legislature's intent and mandate that the court apply factors in 665A that the legislature never intended to mandate. This isn't 665. I think that Judge Hoare did find abuse occurred. The appellant argues that the court is somehow obligated to do a review of 10 years worth of abuse. That's not what the statute said. Judge Hoare applied the statute correctly. The statute requires that if within 10 years the court determines that some abuse occurred, the court has to make a decision as to whether or not adequate provisions can be put in place to reasonably protect both a child and the abuser. Keep in mind, there was no finding that any abuse happened in this case. Judge Hoare did find that within the 10 years abuse had occurred, and he instituted a number of criteria that, from the perspective of the trial court, did provide the adequate provisions necessary under the law. He ordered transitions to occur.
These cases can be very difficult for a trial court to try to fashion an appropriate parent-child contact schedule with an undisputed fact of domestic violence occurring. And shouldn't the trial court give some err on the side of caution regarding parent-child contact when it comes to events such as this? And I agree that there's no indication of any abuse towards the child, but there was clearly an undisputed fact involving domestic violence.
No, I agree with you, Judge, and Justice Cohen, and I believe that Judge Hoare did do that. Judge Hoare heard the evidence that my client had engaged in counseling, that there had been no prior incidents over the last year, that there had been supervised visitation. And I think that supervised visitation is significant in this case because the supervised visitation occurred with the appellant being the supervisor, and no abuse occurred during that supervised visitation. And Judge Hoare still ordered pickup and drop-offs at a neutral site, still ordered that the victim's address remain confidential. But having heard the testimony and exercised his discretion appropriately, he ordered the parent-child contact, but he ordered it in a gradual fashion to further put in place a provision to make certain to the extent that he needed to concern himself with the safety of the child, that happened. So I think Judge Hoare did exercise his discretion appropriately. I think he did take the fact that some abuse had occurred. There was a dispute, in fact, as to what level of abuse occurred, but Judge Hoare did find appropriately under the statute that within the last 10 years, some abuse had occurred. And the appellant really wants to change the statute to, one, require that the trial court judge do an analysis of all abuse that may have occurred over the last 10 years. That's not what the statute requires at all of the trial court judge. Simply protecting a victim if something had happened within 10 years. If something had happened outside of the 10 years, even if the evidence showed it, the court doesn't have to apply 665A. And the 665A-B factors are simply what I called in my brief tools in the toolbox. And it's very important that 665 says shall and 665A says may. And it's up to the court, the trial court, from my perspective, to hear the evidence and then use those tools if necessary. But it's not required, as the appellant is trying to make that happen. I just think it's a misunderstanding of the statute.
And your time has expired, sir, so you'll have to leave it there.
Thank you.
All right, bailiff.